And now let's go back to the first scenario we discussed earlier. That is when a tenant filed an answer. So tenant was served with petition and notice of petition. Tenant came to court and filed an answer. And as I said earlier, in that situation, landlord can expect to have the first court date scheduled in about 10 months after starting the case. That is after landlord served the 14-day notice on the tenant. So when landlord and tenant come to court on that first court date, rather than waiting for a decision, for a formal decision by a court judge, in most cases, landlord and tenant sign a settlement agreement. They negotiate a settlement agreement in court and sign a settlement agreement. That is not necessarily they would sign a settlement agreement on the very first court date, but sometimes it takes a couple of court appearances, but usually, in most cases, sooner or later, landlord and tenant sign a settlement agreement. So why would they sign or why would landlord agree to sign a settlement agreement rather than waiting for a decision by a court judge? This is because to have a decision by a court judge, the landlord and tenant needs to go to trial. And trial is a very expensive procedure because landlord's lawyer needs to prepare a lot of documents. So there is a lot of work for the landlord's lawyer. And also to schedule a trial, sometimes it may take a year, sometimes more. So from a practical point of view, usually it makes more sense for landlord to agree with a tenant on some kind of settlement agreement rather than go to trial. And now, speaking of settlement agreements, the landlord and tenant are free to agree on whatever arrangement they want. But usually in practice, there are two common types of settlement agreement that are quite often signed by landlords and tenants in New York City Housing Court. The first type of agreement I would call a repayment plan. And this is when tenant continues to live in the apartment and tenant is given some time to repay the amount of owed, that is the amount of rent arrears. When I said some time, it could be a couple of months to a couple of years. There is no set limit. So this is flexible. And how it works in practice is that every month, in addition to a current monthly payment for that specific month, a tenant is also paying an additional amount, which is specified in the settlement agreement, an additional amount which is counted toward repaying the amount owed, the amount of rent arrears. And tenant would be paying that additional amount until the entire amount of rent arrears is paid off. And if at some point tenant stops making those payments, landlord can come to court and ask the judge to sign an eviction order. The second type of settlement agreement, which is common in New York City Housing Court, is a so-called pay or leave arrangement. And this is when landlord and tenant set a fixed date in the future. Usually it's a couple of months in the future. And tenant promises to either pay the entire balance of rent arrears by that date or move out of the apartment voluntarily. So when the tenant pays the entire balance, obviously the case is closed. And when the tenant moves out of the apartment voluntarily, this is very good for the landlord because landlord doesn't need to go through the formal eviction procedure with involving marshal and which is very complicated and can take a lot of time. And quite often, in order to, as an incentive to have the tenant to agree to this kind of pay or leave arrangement, a landlord promises to forgive the tenant the amount of money owed if tenant moves out of the apartment voluntarily by that fixed date. So it might seem a little disadvantageous to the landlord because tenant was living in the apartment and was not paying rent. So some amount of rent arrears was accumulated. Now tenant moves out and tenant is forgiven the money owed. So it seems that tenant was living some time for free. But once again, that from the practical point of view, usually that makes sense for the landlord to agree to this kind of arrangement, because otherwise, if the parties cannot agree on any kind of settlement, the case will go to trial. And this is usually very expensive for the landlord and may take a lot of time, could take a year or even more. So from the practical standpoint, from the practical point of view, this kind of arrangement makes more sense for the landlord. So now to summarize what was said in this video offered an overview of the non-payment summary proceeding in New York City Housing Court. So as we said at the beginning, before landlord can start a case against a tenant for non-payment of rent, landlord has to serve 3 notices on the tenant. We discussed 5-day, 14-day, and good cause eviction law notices. So if the tenant receives notices but the rent is still not paid, then landlord has to file petition and notice of petition with the court, wait till the court assigns an index number, and then serve petition and notice of petition on the tenant. And after that, there are 2 possible scenarios. Either a tenant comes to court and files an answer, or tenant basically ignores the petition and notice of petition and doesn't do anything. And in this video, I tried to provide a general estimate how much time it takes before landlord can see the judge and can have a chance to have the case resolved. So in case when tenant defaults, that tenant does not answer the petition and notice of petition, in Brooklyn, a landlord can expect to see the judge within 7 to 8 months after the case was started. And when tenant does answer and does come to court, in that case, obviously in Brooklyn, approximately 10 months after the case was started, landlord and tenant can see the judge for the first time, but obviously not every case is resolved on the first court date. Sometimes it takes, unfortunately, much longer. And also my last point I wanted to mention that while the case is pending in court, quite often tenants stop paying rent, so landlord should be aware of that as well. So that's the end of this video. On the next slide is my contact information. On my website, there is a lot more of detailed information about specifically how to do service of legal papers, as I mentioned in the video, and also a lot more detailed information about the non-payment summary proceeding in general. If you have any questions about landlord-tenant law in New York, please call. I'll be happy to help. Thank you for your attention.